help me to understand, though, going back to Justice Kagan's point, all of the differences that we see between 12 and 11. I mean, you're pointing to two areas that you think are similar, but it seems as though liability arises from the offering or selling of a security by means of oral communication, which doesn't have anything to do, I guess, at least on its face, with a prospectus. And so why would you have to have a registered share in order to give rise to that kind of liability?
Well, this court said in Gustafson that oral communication has been construed to be given that it appears together with prospectus, and in a statute where the structure makes clear that what a prospectus is and when it's obligated to be distributed, that oral statement has to be understood as a reference to the prospectus. That's something along the lines of the prospectus referring to the contents of the prospectus.
All right, so even in a situation where you have a prospectus, my understanding was that a prospectus is part of a registration statement, but I suppose it could also be separate. Am I right about that? Like it's a separate document.
It's a separate document that is physically part of. So the registration statement contains the prospectus that doesn't have all the final information. The final prospectus is filed separately, but it's incorporated as part of the registration statement. So yes, it's part of the registration statement, but you could hand someone a prospectus that doesn't have the full registration statement.
And in that situation where you hand someone a prospectus and this prospectus has misleading or at least arguably misleading information, your view is that unless they did so in connection with a registered share, there's no liability.
Yes, because that's what Gustafson holds. Gustafson says by means of means.
No, I understand, but
okay.
What do we do with the language in the statute, Section 12, that suggests that there is liability with respect to at least some exempt shares? I guess I can't get, if you were right that registration was sort of the core requirement of liability under 12A, how do we have a 12A that applies on its face to some exemptions?
Well, because that's what Congress said. Congress specified the exempt shares to which Section 12 would apply. The reason it did that is because otherwise exempt shares.
But if you were right about your thesis, if you were right that 12A really is all about registered shares, then we wouldn't see an exemption. I appreciate that Congress put it in here, but I think that undermines your argument about what 12A is actually doing.
No, Your Honor, because without that parenthetical that brings Section 3 exemptions back into the scope of liability, all the Section 3 classes of shares would be exempt from Section 12 liability. But Congress wanted Section 3 classes because, you understand, Section 3 exempts an entire class like bank securities or savings and loan securities. They're not subject to the registration requirement, to the Section 11 liability requirements. But Congress, because those are often issued in public offerings, just like non-exempt shares, Congress wanted those public offerings of otherwise exempt shares to be covered by